Your Honor, I'm wondering if this is a township case. I cannot find a file in our system.
Right out of the gate, this case signals something deeper than a routine hearing. There's immediate confusion in the system files not matching, jurisdictions unclear, and that's never a small issue in a courtroom. When administrative errors show up this early, it raises a critical question: how much of the process has already been compromised? The prosecution is unsure. The system can't locate the case properly, and now the judge has to step in to untangle it. This isn't just paperwork, it directly affects the defendant's rights. A misfiled case can delay arraignment, impact legal representation, and even influence how charges are perceived. And notice the tone: calm but alert. The judge is already scanning for inconsistencies. This is where courtroom control begins, identifying gaps before they become legal liabilities. Because if the foundation is unstable, everything that follows is at risk.
I have it as a state case. Let me see. No, this is, well, it is. It was, we entered it wrong. The complaint is clearly a township, but it was entered as a state case.
Your Honor,
Okay,
Conrad Siller on behalf of Pittsfield Township. I do not have that file with me today, so I'd ask that the court adjourn it.
Mr. Williams?
Yeah.
Do you have not been appointed counsel in this case, is that correct?
Correct.
All right. Because I don't think, as I'm looking at the files, things are messed up about it, but it appears to me I had to issue 2 bench warrants, but you've not been arraigned on this matter. All right. So let me at least begin that part of the process. All right. State your name, sir.
Martell Williams.
All right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about May 25th, 2023, at the location of West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of operating while intoxicated. Do you understand the nature of that charge, sir?
Yes, I do.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could also immobilize your vehicle, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I understand.
All right. First question I have for you, sir, is do you wish to be represented by counsel?
Yes.
All right. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams. We will waive any further reading and stand mute and request another pretrial date, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea in this matter.
Now the defense steps in, strategically waiving further reading, standing mute, and immediately requesting a pretrial date. This is a textbook move. It avoids unnecessary dialogue while locking in the defendant's position. Not guilty, no elaboration, no exposure. The judge accepts it cleanly, and just like that, the case transitions from confusion to structure. But here's where things get interesting: the bond conditions. A $20,000 personal recognizance bond sounds lenient on the surface, but the conditions attached tell a different story. No alcohol, no drugs, no weapons, mandatory monitoring. This isn't freedom, it's controlled release. The court is signaling risk without explicitly saying it, and that BAC reading, 186. That's over twice the legal limit. So while the paperwork may have been messy, the underlying concern is very real. The system is now tightening around the defendant, step by step.
Pretrial in this matter will be adjourned to November 1st, 2023, 9 a.m. Found in this case, I had an alleged BAC of 0.186. I'll set the defendant's bond at a personal recognizance $20,000 bond. I'll order standard conditions, including no assaultive behavior or possession of any weapon. Sir, there is to be no possession of any, I need an order, please. There is to be no possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Understand?
I am also going to order that you report over to the Department of Community Corrections for placement on a sober link alcohol tether. You're to do that within 24 hours. I am signing that order now. You understand that, sir?
Understand?
All right. All right. Thank you.
All right, thank you.
Court calls the case, People versus Genevieve Donald.
Mr. Reiser on behalf of the people.
Mr. Donnell. Genevieve Donnell. You're prompting.
Sorry, I'm sorry. The host has asked you to start your video. Okay, sorry. I don't know how to use this. Yeah,
Okay.
so,
You did okay. What's your name?
my name is Genevieve Donna.
All right. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about September 4th, 2023, at the location of 1675 Cypress Point Court, Pittsfield Township, Washington County, State of Michigan, that you did make an assault and/or an assault and battery upon a Kathy Donnell. Do you understand the nature of that charge, ma'am?
Yes,
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
yes,
The second case shifts the tone, but the structure remains identical, and that's intentional. Assault and battery charges, same potential penalties, same procedural flow. But watch the human element here. The defendant's responses, hesitation, repeated yes, signal uncertainty. This isn't confidence, this is compliance under pressure. And the judge notices that. The questions are direct, controlled, and repeated just enough to ensure understanding is on record. Because in court, clarity protects the process. Now, the defense again uses the same playbook. Waive reading, stand mute, request adjournment. Efficient, predictable, effective. But the real shift is coming because unlike the previous case, this one introduces a personal connection. The alleged victim is named. And that opens the door to restrictions that go beyond standard conditions. This is where legal procedure intersects with real-world relationships, and that's where things escalate quickly.
Okay. First question I have for you is, do you want to be represented by an attorney?
what, yes,
Yes.
yes.
All right. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Donnell, and we will waive any further readings, stand mute, and request another pretrial date, Your Honor.
Defendant having waived former reading, standing mute. Court will enter a not guilty plea in this matter. Pretrial in this case will be adjourned to November 1st, 2023, 9 a.m. It's the bond in this case. I'll set a bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assault behavior or possession of weapons. You understand that, man? That's a yes.
Yeah. Yeah.
There's to be no
Yes.
possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
Is there any reason you need to have any contact with Kathy Donnell?
At this time, no. I mean,
At
she's
this
my
time,
mom.
no.
Well, she's
Then
my
I'm gonna
mom.
order no, I'm gonna order no contact with
Okay.
Kathy Donnell. You understand that, ma'am?
Yes.
All right. Anything further regarding bond? Okay.
Your Honor, I'm sorry, would you consider ordering drug testing? My understanding is cocaine or some other controlled substance was a factor here.
What was the alleged substance?
Cocaine.
Got it. All right. Mr. Nell, I'm going to order that you report over to community corrections for drug testing. You understand that?
Yes, like I just go there today or what?
Yes, you're going to have to report over today and make sure that you have funds to pay for the testing. Because of the
Okay.
nature of the drug involved, I'm going to order testing 2 times per week.
Now the court tightens control significantly. Drug testing isn't just added, it's emphasized. Twice per week, random, and at the defendant's expense. That detail matters. Financial pressure becomes part of the legal burden. And notice how the judge frames it. Because of the nature of the drug involved. That's a subtle but powerful signal. The court isn't treating this as minor, it's treating it as a behavioral concern that needs monitoring. And the defendant's response? Immediate confusion. Do I go today? That moment reveals the gap between legal instruction and real-world understanding. The judge corrects it quickly, reinforcing urgency. This isn't optional. This is compliance or consequence. And here's the bigger picture. The system is layering restrictions. No contact, no substances, now active testing. Each condition adds weight. Each condition increases the risk of violation. This is how courts maintain control without detention.
Okay,
Random. You understand that?
yes.
All right. Okay, thank you.
Thank you.
Court does call the case, People versus Jason Westlake. Excuse me.
Patricia Reiser on behalf of the people.
Good morning, Your Honor. Mark, this was Jason Westlake, correct?
Yes, it is.
Okay,
2 cases.
yeah. Good morning, Your Honor. Marcia Kracher, case number
Ending in 764.
764. That is correct, Your Honor. And I think the public defender has another case up as well.
Yes, good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Westlake on 0659.
Mr. Westlake, please state your name, sir.
Jason Scott Westlake.
Thank you. All right, what are we doing?
Your Honor, Mr. Westlake has a case that's currently up in circuit court. We're attempting to resolve it. We'd ask for a 2-week adjournment. If that is not able to be resolved up in circuit court, then we would resolve these cases down here at that time, Your Honor. That's how my,
I would join in that request, Your Honor.
When is the case up? And what date is that up for?
it's actually currently set for trial, Your Honor. We are continuing in negotiations with Ms. Londy up in circuit court, and we should have an answer on some requests no later than 2 weeks, Your Honor.
November 1st, 2023, 9 a.m.
Your Honor, thank you very much.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you, sir.
This exchange looks simple, almost routine, but it's strategically important. The defense requests time, citing ongoing negotiations in a higher court. That tells you this case is part of something bigger. There's leverage being built elsewhere, and this courtroom is essentially pausing to see how that plays out. The judge agrees, but doesn't lose control. Bond remains, conditions remain, timeline is fixed. November 1st. That date becomes the anchor. Everything now moves toward that point. And this is where courtroom efficiency shines. No unnecessary dialogue, no emotional escalation, just procedural precision. But underneath that calm surface is a negotiation battle happening off camera. Deals, reductions, strategy shifts. The real outcome of this case may never be decided in this room, but this room controls the timeline. And in law, timing is power.
Let's call the case of the people versus Gary Lee Hall.
Patricia Reiser on behalf of the people.
This is an arraignment pretrial without counsel, and Hall is not present.
Gary Lee Hall. No response. Bench warrant will issue for defendant's failure to appear. Ms. Reiser, do you have the alleged BAC?
Yes, Your Honor, it's 0.14.15.
Thank you. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I'll give a 10% privilege at this time on this. Given the nature of the charge, that warrant will issue immediately. Court does call the case of the People versus Nicholas Clements.
Patricia Reiser on behalf of the people.
Arraignment is present.
Clements?
Yes, sir.
Do you have a camera?
Oh, yes, sir. Hi,
Hello, what's your name?
Nicholas Clements. Nicholas
All
Steve.
right, Mr. Clements, you are before the court on a misdemeanor complaint that alleges that on or about June 27, 2023, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge, sir?
I believe so. I don't know. Yes, sir. I don't have
Okay.
spoken to a
Do you
lawyer.
understand that you're charged with driving while intoxicated, or what's commonly known as drunk driving? Do you understand that?
Correct, but I wasn't.
This is a critical moment and a dangerous one for the defendant. He tries to respond emotionally, "I wasn't," but the judge immediately shuts that down. Why? Because this stage is not about arguing facts. It's about confirming understanding of charges. The court isn't asking for a defense, it's establishing legal awareness, and that distinction matters. If the defendant starts defending too early, it can create contradictions later. The judge redirects cleanly, keeping the process intact. This is courtroom discipline in action. And it highlights something important. Many defendants don't fully understand when to speak and when to stay silent. That's why representation matters. Because without guidance, even a simple response can complicate a case. So the judge refocuses charge, penalties, acknowledgement, step by step, controlled, precise.
Yes.
Okay, well, I'm not asking whether or not you were or not. I'm indicating you understand that's what you're charged with.
Understood.
All right. It is alleged in this case that you were under the influence of a controlled substance. You understand that, sir?
I do.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. Your vehicle could be subject to immobilization. The court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
I believe so.
Well, do you understand that those are the possible penalties, sir?
Yes, sir. Yes, Your Honor.
All right. Do you have any questions regarding the charges or the possible penalties, sir?
Not this moment.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
I do.
This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Clements. We will waive any further readings, stand mute, and request a pretrial date, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned November 1st, 2023, 9 a.m. Bond in this case, what is the alleged drug?
Your Honor, it's marijuana and amphetamines.
Got it. Bond in this case will be set in the amount of $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or use of any weapons or possession of weapons. You understand that, sir?
I do.
Another bond decision, but this one carries added weight. The mention of controlled substances, marijuana, and amphetamines changes the court's posture. This isn't just about driving anymore, it's about substance influence, and the conditions reflect that. Weekly testing, strict prohibitions, immediate reporting. The system is now actively monitoring behavior, not just restricting it. And notice how the judge ensures clarity, phone numbers, instructions, follow-ups. There's no room for confusion here. Because once conditions are set, violation becomes the defendant's responsibility. And here's the key question. How often do defendants underestimate these conditions until it's too late? Because missing one test, one call, one requirement, it all stacks. The court builds a framework, but the defendant has to operate within it perfectly. And that's where many cases start to unravel.
There is also to be no possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
I do.
I'm further going to order that the defendant is to report over to the Department of Community Corrections, for 1 time per week testing on this case. All right, you need to report within 24 hours, sir.
Where do I find that information?
Okay. Do you have something to write with? Let me give you a phone number to call.
Go ahead.
Community Corrections phone number is area code 734-973
Okay.
4520.
All right.
All right, I'm going to give you another phone number to call. I need you to contact the public defender's office.
Okay, sir.
All right, and that number is area code 734-222-6970.
Okay.
When you call them, I need you to give them your name, a valid phone number, and a valid email address so they can contact you. Understood?
Understood.
All righty. Thank you. We'll see you in a couple weeks.
Thank you, sir.
Thank you. Court does call the case of the people versus Marcellus Martin.
Patricia Reiser on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Martin. Mr. Martin, can you unmute and state your name for the record, please?
I had this as a Pittsfield case.
Conrad Siller on behalf of.
Yeah, I was gonna say I jumped the gun. Sorry, Mr. Still.
All right.
All right.
Okay.
It's all right.
This moment introduces something subtle but important miscommunication between legal parties. Even the defense acknowledges confusion. I jumped the gun. That's not just a casual remark, it reveals how quickly assumptions can disrupt courtroom flow. And then comes the bigger issue. The defendant is in custody, and the defense didn't know. That's a serious disconnect. It changes everything. Strategy, timing, even the urgency of the case. The judge adapts quickly, granting an adjournment, but also probing the situation. Why is the defendant in custody? What's the status? These questions matter because they affect bail, release, and legal positioning. And again, the system stabilizes itself. Even when information is incomplete, the court moves forward with structure. That's the pattern you're seeing across this entire session.
All right. What are we doing on this case?
Your Honor, it's my fault. I did not know Mr. Martin was in custody. I was trying to call him, but didn't answer. He didn't answer, and I can only assume now that it was because he was in the jail. So I would ask for an adjournment to allow us to speak. I'm not sure at this time what he's in for, if he's being held in this
I'll
case.
adjourn the matter to November 1st, 2023 at 9 a.m. Mr. Martin, state your name, please.
Marcellus Martin.
All right, Mr. Martin, you're not in on this case because it's a PR. What are you in on currently?
Well, right now I'm waiting on Ipsy Police to bring my paperwork in. I supposed to have got out here yesterday, but they don't have the paperwork in. So today I goes in today at 1 o'clock for domestic violence. Hopefully the paperwork is in. If not, they say they're gonna let me go because I've been here for 48 hours with no paperwork. So I don't know what's taking these guys so long to drop off the paperwork, but obviously.
Okay, no, I don't know because I don't think that's my case. It might be an afternoon arraignment. Okay, so here, I don't know, sir. The only thing I was looking at is trying to figure out what you were in on because you have a PR bond here, and I was going to change it to a nominal bond so you got credit. But it sounds like to me that you might be released. So I'm going to leave your bond at a PR on my case right now, okay? And we'll do that. And I'll set this for November 1st, and we'll see you then, okay? Thank you.
Thank you, Your Honor.
Court calls the case, People versus Nathulian Mason.
Patricia Reiser on behalf of the people.
This is an arraignment counsel without, arraignment pretrial without counsel, and she is not currently signed in, but she has had contact with the clerk's office this week.
Now, technology becomes the problem. The defendant isn't present, not by choice, but due to connection issues, weak Wi-Fi, dropped calls, failed communication. And this is where modern courtrooms face a new challenge. Remote hearings depend on stability, and when that fails, the entire process stalls. The judge can't proceed without proper arraignment. Rights can't be confirmed, charges can't be acknowledged, so the only option is adjournment. But think about the impact delays, extended timelines, unresolved cases, and all of it caused by something as simple as a poor connection. It raises a bigger question. Is the system fully equipped for digital proceedings? Because fairness depends on access. And when access fails, justice pauses.
To say what?
Attempting to sign in, I believe.
All right, this is set for arraignment pretrial. This individual has had contact with the clerk's office, but is not here currently. So what I will do is I'll adjourn this arraignment pretrial out to November 1st, 2023, 9 a.m. All right. And we'll see if they can get themselves on by that time. Hello,
I'm here. I'm trying to
what's your name? What's your name, man? You're Miss Mason? Okay, Miss Mason, I can't make, you need to be arraigned on this charge. And so I can't make out, you've got a very weak Wi-Fi signal. She dropped, right?
Yep, she's gone.
She's gone. All right. I will send her a chat that I've adjourned her matter out to the 1st. She's back on. She dropped again. So just do that and we'll see if we can get a better connection on that day. Court does call the case, People versus Mario Brown.
Patricia Reiser on behalf of the people.
Bridget Coons on behalf of Mr. Brown. Mr. Brown, if you can, unmute yourself or get one of the jail staff too, and then state your name in full.
Mario Brown.
Your Honor, this is set up for a pretrial. We would be asking for adjournment so that we can continue negotiations.
I'll adjourn this matter then to November 1st, 2023, 9 a.m. Defendant's bond with its conditions will continue.
Okay. And Mr. Brown, I'll
Thanks.
come in the jail tomorrow to go over what's going on.
Okay.
All right. Thank you, Mr. Brown.
This final sequence brings everything together. Multiple cases, different circumstances, but one consistent outcome: adjournment to the same date. November 1st becomes the convergence point. And that's not accidental. It allows the court to maintain order across a wide range of situations, negotiations, missing defendants, procedural gaps. But there's also a pattern of accountability. One defendant fails to appear, bench warrant issued immediately, $155,000 bond, no hesitation. That's the system enforcing consequences. Others comply, they receive structured conditions and time. The contrast is clear: show up, follow rules, stay in process, or face escalation. Judge Simpson maintains that balance throughout: controlled, consistent, and decisive. And that's the real takeaway here. The courtroom isn't chaotic, it's calculated. Every decision builds toward resolution. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.